Good morning, everyone. This is going to be a quick live. I just got off work and came home, walked the dogs, and worked out. And now I'm going to do this live real quick before I go to bed. Um, there were some more things dropped on Aaron Spencer's case that I want to go over. And there's a couple things on Wesley Hennard's case, which is the 17-year-old that Judge Barbara Elmore let out on low bail for the grape of the grape and essay of minors and the internet corn, so to speak. There were some things that dropped on his case as well, so I wanted to go over those. But before I do that, has anybody heard about the new case? And I think it's coming out of Pennsylvania, but I'm not positive, or Philadelphia maybe, about the man who they staked him out apparently and watched him desecrate some graves. Apparently there's an old cemetery in the town, so to speak, where the actual deceased was taken. Okay, I'm frozen. Why am I frozen? Okay, so I believe I'm live. So sorry about that. I don't know what's going on. I keep freezing up. My internet is not cooperating with me. But anyway, yeah, there's a story that's just coming out today, 14 hours ago, actually, about a man, I believe it's in Philadelphia, an old cemetery in town was having the graves desecrated and the actual skeletons were being removed. And they staked out the cemetery and they finally caught the guy. They served a search warrant on his home and found over 100 skeletons, different ages. There were baby skeletons apparently. Yeah. And then they served a search warrant on his storage unit and found, I think, 5 more, they said. They said it's going to take a lot of time to figure out who is who and if they're all complete skeletons. They didn't say. But yeah, so we're going to read that real fast and then we'll go over to Aaron Spencer's new filings. I had it on here and then I refreshed and now it's gone. So, here we go. Pennsylvania is where it's at. So, my dad's was from Pennsylvania. Sorry, that's our new puppy, our new addition. She's quite the handful. Okay, January 8th. Investigators have arrested and charged a Pennsylvania man accused of ransacking a Southwest Philadelphia cemetery of human skeletal remains, authorities said Thursday. Jonathan Garlack, 34, of Ephrata, Pennsylvania, was arrested Tuesday night at Mount Moriah Cemetery, the Delaware County District Attorney's Office said in a statement. Police were conducting surveillance of the cemetery following reports that it had been burglarized since November. Officers observed the suspect's car with numerous bones and skulls in plain view in the back seat at around 8 p.m. The suspect was then observed exiting the cemetery with a burlap bag, crowbar, and other items, and was then taken into police custody. Under questioning, Gerlach allegedly admitted to investigators that he had stolen about 30 sets of human remains. I believe they found more than that. A subsequent search warrant of his residence recovered what investigators believe to be more than 100 full and partial human skeletons. An additional 8 human skeletons were found in a separate storage locker in Gerlach's name, Delaware County District Attorney Tanner Rouse told reporters during a Thursday press conference. Quote, very simply, detectives have recovered an awful lot of bones at this point, and we are still trying to, I think, determine who they are. They left a word out. Where they are from and how many we are looking at. And it's going to be quite some time before we have a final answer, he said. He's now arrested, quote unquote. Gerlach has been charged with nearly 500 offenses, including 26 counts of burglary, 100 counts of abuse of a corpse, 100 counts of theft by unlawful taking, and more than 4 dozen counts of intentional desecration, among others. Rouse said the sting operation was launched after more than 24 mausoleums and graves were quote-unquote desecrated at the cemetery in the past few months. Officers laid in wait and eventually, quote, and caught Mr. Gerlach as he desecrated yet another monument, end quote. Quote, very simply, detectives walked into a horror movie come to life the other night, end quote. Quote unquote, guys, this is an unbelievable scene that no one involved, from myself to the detectives to the medical examiners that are now trying to piece together what they are looking at. Quite literally, none of them have ever seen anything like this before. Rouse described the alleged crime as being quote unquote horrific, saying that they found among the remains those they believed to belong to children, some as young as months old. Some of the remains were also hundreds of years old, he added. He added that they are, quote unquote, almost certain that the remains they recovered also came from other cemeteries. They were found mostly in the suspect's basement, he said. Some were hanging, some were skulls on a shelf. He said they do not know what he was doing with them. Quote, we are trying to figure out exactly what went on in that home, end quote, he said. It is still unclear, and given the enormity of what we are looking at and the sheer kind of utter lack of reasonable explanation, it is difficult to say right now at this juncture exactly what's in place. We're trying to figure it out. Rouse did confirm to reporters that part of the investigation is a Facebook group that is seemingly a marketplace for selling human bones. More charges are possible, he said. Gerlach is being held on a $1 million cash bond. The suspect has a preliminary hearing scheduled for January 20th. So, want to watch the press conference real fast?
Here today because of the arrest of 34-year-old Jonathan Gerlach of Ephrata, Pennsylvania. Over the course of the last several weeks, detectives from Yeadon Borough as well as Delaware County CID became aware that from November of 2025 up until 2 days ago, January of 2026, Mount Moriah Cemetery had been burglarized by, at that point, an unknown individual. 26 separate mausoleums and or underground burial sites had been torn into and, for lack of a better word, desecrated. Investigation took place. Yaden does on this for doing good old-fashioned police work, going through LPRs, tracking physical evidence, piecing together a suspect, cooperating with CID. We developed that suspect. We laid in wait, and we eventually watched and caught Mr. Gerlach as he desecrated yet another monument as recently as 2 days ago. He was taken into custody. Search warrants were executed at his home in Ephrata, where over 100 human skeletons were recovered. And that's in part, at this point, we are still trying to figure out how many of those are complete and what exactly we are looking at. A separate storage locker was found to be in Mr. Gerlach's possession. That also was in Ephrata. We found there 8 more human remains. Very simply, detectives have recovered an awful lot of bones at this point, and we are still trying to piece together who they are, where they are from, and how many we are looking at, and it's going to be quite some time before we have a final answer. He is now arrested. Bail has been set at $1 million cash by Judge Williams. He is in on 26 counts of burglary, criminal trespass, and a host of other offenses. Kelly Wilson, who's handling our media affairs, is going to pass out a complaint so that you guys have the complete list of charges at your disposal. Very simply, detectives walked into a horror movie come to life the other night, guys. This is an unbelievable scene that no one involved, from myself to the detectives to the medical examiners that are now trying to piece together what they are looking at, quite literally. None of them have ever seen anything like this before. When I was 16 years old, a friend of mine was killed in a car accident, and I personally have visited his gravesite, as many people do when they lose a loved one. I know his parents have also visited that site. I cannot imagine what it would put them through to know that someone like this guy had dug up those remains and was doing God knows what with them. It is truly, in the most literal sense of the word, horrific. I grieve for those who are upset by this, who are going through it, who are trying to figure out if it is in fact their loved one or their child, because we found remains that we believe to be months-old infants among those that he had collected. So our hearts go out to every family that is impacted by this. Some of these are hundreds of years old. We are trying to figure out exactly what we are looking at. We quite simply, at this juncture, are not able to date and identify all of them. I want to make some thank yous here because this was truly a collaborative effort. As you guys can imagine, this spanned from here to Lancaster County. The Ephrata Police Department was instrumental in gaining access to and executing that.
I caught it. I caught it. What do you guys think about that? That's crazy. Crazy story. I didn't know that there was a black market for skeletal remains. I guess it takes all kinds. There's a black market for organs, and live people. So why not have a black market for skeletons? I'm at a loss for words. It blows me away that, I mean, people will buy and sell literally anything. There's a market for everything. There's somebody out there that would buy there's probably somebody out there that collects dog poop. I mean, honestly, as crazy as that might sound, I wouldn't doubt it. Mankind just kind of disappoints me every day. Something happens where I'm let down by the things that my fellow man does. So there's that. So let's move on to Aaron Spencer. Whoops. Now my dogs are going to bark. Like I said, I don't know if you caught it, but this is going to be a quick live. I just wanted to update you on the latest in the Aaron Spencer case, since it is coming up, I believe, on the 26th. Is that correct? And also on the Wesley Hennard case. Like I said, he's the young man, the 17-year-old who Judge Barbara Elmore let out on a pretty low bail, and he was arrested for the rape and essay of minors, and also the production and the possession of internet porn. And while he was out on bail for Judge Elmore, he reoffended. Same thing. The rape and essay of a minor girl, I think once or twice actually. And I don't think he was caught with any more internet porn because they confiscated all his internet capabilities. So, but he still reoffended, and that's on Barbara Elmore, who also, if you're not familiar with her name, she is the judge in Aaron Spencer's case, and she is the judge who was also she was also the judge for Fossler's case, his criminal case for the rape and essay of Aaron Spencer's daughter. And she also let I think his name's Michael Fossler, but she let Fossler out on a pretty low bail also. And he also reoffended while he was out on bail and had a protective order against going to see Aaron Spencer's daughter. And yet he came and took her out of her bed in the middle of the night. And that is the night that his life was taken. So that's two men in close proximity of each other that were both let out on pretty low bail. And they were both going to be on trial for the rape and essay of minors. The only difference is one was a 17-year-old and one was Fossler, who was 60-something. But this Judge Barbara Elmore has got some issues, I think, because I did a stream on her. And if you want to look at my playlist, I did two streams on her about some history she has with some of her decisions being overturned and some of her decisions being controversial. And these are two of them. So if you want to look at those videos, she's got a pretty interesting background as far as controversial decisions go. So let's move on with Aaron Spencer. He does go on trial this month, and I do not believe that there are cameras allowed in the courtroom. So we're just going to have to wait every day for the go over, I guess is what it's called, the evaluation of each day by reporters and fellow YouTubers. And I don't know if any of the YouTubers I watch are going to be there. I'm sure there will be. I think, I think Defense Diaries might be going. I'm not positive, but for some reason I feel like he might be going. But we'll stay on top of it, and we will be updating on a daily basis. Every day they hold court, we will definitely be updating and keeping everyone posted on that. Keep your prayers with him and his family and his daughter, who, is still going through it. I mean, this will never leave her. She may learn to live with it, but it'll never leave her. And it's thanks to Fossler, obviously. I mean, he's ultimately the perpetrator, but I would say that Judge Elmore didn't help the matters any, if you want to be. It didn't help discourage him from reoffending, that's for sure. As far as, and that's my opinion. You know, I mean, everybody's entitled to their own opinion. That's just my personal opinion. And I feel like I don't know how she sleeps at night. So, okay, so this is a motion to reconsider ruling limiting evidence about decedent to his reputation in Lonoke County. Now, remember, I did a video not too long ago about how she was actually going to allow Aaron Spencer's attorneys to bring up Fossler's reputation in the public eye, which isn't ideal, but it's better than nothing, right? I mean, because ultimately, if you don't have any background on this Fossler guy, how are they going to understand the vigilante justice that they're trying to prove, right? So it would actually benefit the Commonwealth also if the defense was allowed to bring in Fossler's past discretions, so to speak. I would think. I mean, I'm not a lawyer, I don't know, but I would think that that would help the Commonwealth also, because then they can really drive home the vigilante justice theory that they're trying to drive home rather than self-defense. And I know it would help Aaron Spencer's case if the defense was allowed to bring it all in, but she just approved of his reputation. She didn't approve of his prior charges because he was never found guilty. She wasn't going to allow the fact that he was arrested on suspicious of these on suspicion of these crimes. She wasn't going to let any of that in. She was just going to let his reputation in, which is better than nothing. Okay. Well, I guess Aaron Spencer's lawyers decided to file a motion to have that ruling reconsidered. Okay. And that's what this is. Comes now the defendant, Aaron Spencer, by and through his attorneys at Lassiter and Casanelli, and for his motion states, following a pretrial hearing in the above case on December 17, 2025, this court ruled that the defense would be permitted to introduce evidence pursuant to Arkansas R. Evidence 404 regarding opinion or reputation testimony. So people's opinions, the public opinion, or reputation testimony as to the decedent Michael Fossler's character for violence. However, this court limited any Rule 404A evidence to testimony about Fossler specifically in Lonoke County. Now, I don't know what that means. Did he not commit the crimes against Aaron Spencer's daughter in Lonoke County? Because I thought that's where he was going to be on trial. That's why Barbara Elmore's the judge. Arkansas R. Evidence 404A authorizes admission of evidence of a pertinent trait of character of the victim of the crime offered by an accused, or by the prosecution to rebut the same, or evidence of a character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor. It explains that in all cases in which evidence of character or a trait of character of a person is admissible proof may be made by testimony as to reputation or by testimony in the form of an opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct. Okay, so that sounds promising. It explains that in cases in which character or a trait of character of a person is an essential element of a charge, claim, or defense, proof may also be made of specific instances of his conduct. Neither Rule 404 or 405 mention the word community. Okay. Where character evidence is offered in support of the contention that the decedent was the aggressor or to characterize and explain his acts, the defense is restricted to proof of general reputation in the community where the decedent lived. Quote, every fact that would be competent evidence in a case of self-defense by the person defended is competent where the killing by the accused is alleged to be in defense of another, end quote. No case has interpreted this to mean where the decedent lived at the time of his death. Consistent with rules 404 and 405, in a justification case, specific instances of conduct of the decedent not known to the defendant are not admissible unless on cross-examination. The court's case law regarding specific instances of conduct within the knowledge of the defendant makes clear that there is no limitation to the specific community where the decedent lived at the time of his death. Reversing murder conviction because circuit court erroneously precluded defendant from introducing evidence he was aware decedent had killed people in another state. It would not make logical sense to restrict opinion/reputation testimony to only the decedent's community at the time of death. This evidence is relevant as probative of who was the aggressor, where a defendant asserts that he was justified in killing the decedent. Limiting the rule to the opinion or reputation of the decedent in a small community where he lived at the time of his death could narrow the rule's application to nothing where, for instance, a person acted violently only outside of the area in which he lived, moved frequently, or did not have roots in a particular community. It also makes it unclear what quote-unquote community refers to. Is it a county, the city in which the decedent lived, the state, or a larger area that he frequented? Does it include an area he frequently visited or spent overnights? Limiting Rule 404A evidence, as the court has done, does not comport with the purpose of the rule. A person's reputation in the community does not change merely because they happen to leave that community. A violent person is still a violent person, even if they move out of state, just as a peaceful person is still a peaceful person, even when they leave town on vacation. Fossler's reputation for violence and aggression in the communities in which he lived is admissible. Whether that was in Indiana, Arkansas, Pulaski County, or Lone Oak County. Moving somewhere to get a fresh start does not absolve one of their reputation in the communities in which they lived up to that point. Now, I'm wondering, remember on one of Melanie Little's streams, she showed a video of a YouTuber who interviewed one of Fossler's past victims from Indiana, I believe, ironically enough. And she was a young girl at the time, and he worked for the police department in Indiana at the time. And her mom and dad were separated or divorced, and she couldn't get away from him because he was a police officer. And so her mom sent her away to live with her dad in Arkansas, a little town in Arkansas. And she found out through this case that she literally lives a mile or two within walking distance of Fossler, or she lived before he was killed, before he died. She lived within walking distance of this man and never knew it. So I'm wondering if they're talking about maybe bringing up his history with her. Is that why they're mentioning Indiana and whatnot? I mean, it makes you wonder, right? I mean, it sounds like they're describing what he did to her as a young girl. I could be wrong. But that's what it sounds like to me. Let me see. Okay, a Lonoke County jury will be sufficiently able to give any evidence of Fossler's reputation in communities outside of Lonoke County, communities in which he spent substantial portions of his life, the weight such evidence is due. Thus, the defense requests that the court reconsider its ruling limiting Spencer's admission of Rule 404A evidence and permit 404A evidence and permit reputation and opinion evidence from people in the communities in which Fossler lived, not only Lonoke County. Wherefore, the defendant, Aaron Spencer, respectfully requests this court reconsider its ruling limiting Rule 404A evidence regarding the decedent to his reputation in Lonoke County, and for any and all just and proper relief to which he may be entitled. So, I don't know. To me, it sounds like that's what's going to happen, and I don't know what's going on here. Why is it saying picture in picture? What does that mean? Oh, it's gone. Okay. So let's move on. This is a motion to reconsider the exclusion of Carrie Landau's expert testimony. I believe she is an expert on SA. I'm not positive, but I believe that's what she is. Okay. So, motion to reconsider exclusion of Carrie Landau's expert testimony regarding SA of minors. Comes now the defendant, Aaron Spencer, by and through his attorneys at Lassiter and Casanelli, and for his motion states, expert testimony about the dynamics of child exploitation and how offenders use grooming tactics to abuse their victims has been repeatedly held admissible. And then it gives some case law as an example. Affirming admission of expert testimony about the grooming process and how Pond had groomed his minor victim in that case. While this case presents an unusual fact scenario, this testimony is admissible and necessary to ensure the jury has all relevant information, and that is the truth, and that Spencer is afforded the due process that he is guaranteed to him. The defendant therefore asks the court to receive the material herein and reconsider its prior ruling, which was made without any substantial information as to the anticipated expert testimony. And she really should have waited for the voir dire before she decided on that, I think. Despite this case involving a murder charge rather than S offense, the case law substantially supports the admission of evidence about child SA, specifically including grooming, and it is highly relevant to an understanding of Spencer's and his daughter's actions leading up to and on the night of the alleged criminal act. The evidence is relevant to understanding Spencer's daughter's actions in leaving her family home to meet with her SA, her abuser, and Spencer's concerns that she was in imminent danger, even if she did not realize it. The testimony will clearly help the jury understand the evidence in the case. And then there's a footnote. Fossler stood charged with 2 counts of internet stalking of a child that results in a meeting with a child under age 15, a Y felony, 2 counts of SA in the 4th degree, a D felony, 2 counts of S indecency with a child, a D felony, computer child porn, a B felony, and 36 counts of possession of child porn, a B felony. The evidence of these offenses was indisputable. In addition to violating an order not to have contact with minors, Fossler committed an and other criminal offenses after his arrest and on the night of October 7th and morning of October 8th, 2024, which is when he was killed. It is essential that the jury understand certain dynamics of child SA in order to properly evaluate the evidence regarding the events leading up to October 8th. The state has suggested that the minor was not being victimized. That just blows my mind. And was not in imminent danger on October 8th, pointing to her having, quote, snuck out of the house. You know, she was the only witness testifying in Fossler's case. So what do you think he was going to do with her? He was facing life in prison. Do you think he's going to just let her take the stand? Absolutely not. I don't believe so at all. Out of the house with Fossler that morning and, quote, not actually kidnapped, end quote. And through her communications with Fossler and others, including her initiating contact with him earlier in the, quote unquote, relationship and in reestablishing contact after his arrest. The jury should be permitted to hear from a witness who can provide testimony based on specialized knowledge, training, and experience to assist them in understanding the evidence about SA and contextualize the interactions that led to the event ending Fossler's life on October 8th, 2024. While Spencer was aware of some dynamics of child SA like grooming and learned more after Fossler's July 2024 arrest, or July of 2024 arrest, he is entitled to present the jury with evidence from an expert who can provide reliable and articulate testimony to assist the jury in evaluating the claims made against him. The defense has proposed Carrie Landau provide such testimony. Landau is a 21-year veteran of the FBI, where she primarily worked on crimes against children cases involving the exploitation of minors, including sex trafficking. She has worked in the field of SA of minors since 1996. She has conducted well over 1,000 interviews involving the exploitation of minors, including interviewing hundreds of victims and hundreds of offenders. She has received more than 1,000 hours of training and instruction in investigation of crimes against children. Just one second. Sorry about that. She's full of piss and vinegar, I'm telling you. From various agencies, including the FBI, Department of Justice, and the National Center for Missing and Exploited Children, among others. She has provided training and education to law enforcement officers, social service agencies, healthcare workers, attorneys, parents, and school staff across the United States and internationally. She has provided expert testimony on these topics many times and continues to work with child advocacy centers, other nonprofits, and state and federal governments, groups, and task forces to improve investigations, develop standards and protocols for law enforcement officers, and improve services to victims. As the expert witness, Carrie Landau can explain offenders who SA children use manipulation, power, and control to gain access to and compliance by minors. They target minors who are vulnerable and often have boundary issues, feel lonely or misunderstood, or have self-worth issues, aligning themselves with the child's feelings and distancing others in the child's life. Minors struggle with a limited understanding of sexual boundaries and are more trusting of adults, desire the approval and affection of adults, and struggle to identify manipulation by adults. Offenders build the trust of the minor through attention, flattery, concern, and kindness, and create dependence, with the child becoming convinced he or she is part of the decision-making process and desensitizing the child to the sexual depravity that they experience when in person. It makes me sick to my stomach to read about this. The grooming process can be subtle, but creates a dependence that the child views as a loving relationship instead of abuse. It is common for the minor victim to initiate or reinitiate contact with the offender, to seek out the offender's love, concern, or forgiveness, remorse for trouble caused by the discovery of the relationship. And that's the point that Aaron Spencer's daughter was at with Fossler. She probably felt guilty that he was going to be on trial for his life because of the relationship he had with her. The appearance of willingness or desire by the child does not change the abusive. Yeah, this is obvious, you would think. The appearance of willingness or desire by the child does not change the abusive nature of the interactions. And yet the Commonwealth would have you believe that it does. The grooming and manipulation create a bond between an abuser and his victim that renders the child unable to identify the danger presented by the offender. Instead, the child feels sadness, shame, and self-blame for failing to protect the offender, as the offender in the child's mind has protected the child. Just sick. Evidence of this nature is not within the common knowledge of many jurors. I mean, look at the Commonwealth. It's not even in their common knowledge, and it should be. They know better. They deal with victims all the time of SA. Grooming is a quote, subject about which layperson would have little or no experience. The expert testimony is relevant in that it provides the jury with information about how research and experience shows abuse of a child oftentimes does not occur all of a sudden, end quote. Discussing the national acceptance of expert testimony concerning battered wife syndrome to help the jury understand the evidence, such testimony can help explain the perception of danger, dispel misconceptions about patterns of abuse and response, make it easier to understand the overall context and dynamics of the abusive relationship, contextualize the circumstances, and assist in evaluating the reasonableness of the defendant's actions. Discussing and citing cases regarding expert testimony concerning battered spouse and battered child syndromes as helping the jury to understand perceptions and behavior at the time of the killing and relevant to reasonableness of the act. Collecting cases nationally where this type of testimony has been approved and explaining that opinions regarding child SA and grooming may assist the jury in understanding how a minor may be enticed, induced, or coerced into illegal SA without physical force, and may also assist the jury in assessing evidence that some alleged victims repeatedly interacted with Jeffrey Epstein, seemingly voluntarily, even after they suffered abuse. In this case, the circumstances and characteristics of the abusive quote-unquote relationship between Fossler and Spencer's child are consistent with what are commonly seen in cases of child SA exploitation. Information about the dynamics of these quote-unquote relationships, specifically grooming, will assist the jury in understanding evidence of a 14-year-old girl's continued contacts with her abuser, and her failure to appreciate the danger he presented. This testimony will help explain the perception of danger, dispel misconceptions about the patterns of child SA and responses of the child, make it easier for the jury to understand the context and circumstances presented, and assist in evaluating the reasonableness of Spencer's actions. If permitted to do so, Landau was testified consistent with the assertions above and below. SA in these cases is primarily about power, especially when the adult is physically, emotionally, and socially more powerful. The dynamics of power and control in child SA cases are evident even when no physical force is used. SA cases are less about the actual act of sex and more about the power, control, and exploitation of vulnerabilities of victims. When an older offender abuses a child, the age gap itself depicts a power imbalance. The lack of worldly experience for a child puts them at risk due to their lack of awareness and ability to sense danger, deception, and trickery. Children can be exploited due to a limited understanding of sexual boundaries at their age, and they tend to trust adults easily. Children desire the approval and affection of adults, and they struggle with identifying manipulation by the same adults that they seek approval from. Grooming is the systematic, deliberate use of power over a child. Offenders often groom children to make them accessible, vulnerable, and compliant. Predators involved in the SA of children use these manipulative tactics that are often referred to as quote unquote grooming to keep the child engaged and convinced that they too are part of the decision making in these situations of abuse. The grooming of a child can include building trust through attention, flattery, and kindness, complimenting the child and paying attention to them, especially in moments when the child feels that there's no one else doing so. It is effective, and even more so if the child feels alone or struggles with self-esteem issues. Once the child engages with the offender in sexual conversations, this desensitizes the child and allows for more pervasive ways in which the behavior can continue once they are in person and alone with one another. This gradual but deliberate behavior is encouraging, convinces the child to comply with requests from the offender, and increases the likelihood that they will comply once the offender and the child are physically alone together. An offender may start the relationship with what appears to be an innocent touch or small compliment toward the child about their body. This is a way that offenders begin to gradually test victims to cross boundaries and normalize behaviors. If the child provides nude photographs and or videos, the offender continues to push the boundaries. Praise by the offender often follows these conversations so that the child is reminded that they did a good job and made the offender happy and have value. The tactics used by offenders in SA cases are often subtle. Victims often cannot articulate and have a challenging time identifying what is happening to them. Often the tactic of confusion and dependence with the offender and victim go hand in hand. Physical chains are rare in these cases, but victims can become compliant and appear to go along with the relationship/abuse. Therefore, no chains are required, which is what she did. That's why she snuck out that night. Predators target vulnerable individuals, making it easier to control and manipulate them. They seek out those they perceive as less likely to react negatively to efforts at grooming and abuse, who have less access to people they believe will understand their situation and or who are less likely to report anything inappropriate to people who would intervene. They seek out children who feel misunderstood or involved in family conflict and or who are emotionally vulnerable and have trouble asserting boundaries, which I find odd because Aaron Spencer's daughter told her cousin about it, I believe, and she was pretty open with her cousin about it. She was pretty forthcoming about it with her cousin, so I'm not quite sure where she fits into all that, but he obviously exploited her and her kind nature. In the common instances in which a minor victim may appear to initiate contact with the offender, it is sometimes difficult for adults to understand. The offender preys on the vulnerabilities of victims and youth with the focus on grooming and convincing them to become involved in what they believe is a loving, caring relationship. The offenders often prey on the confusion of teenage life and the uphill battle many young people face. Increased vulnerabilities often include self-esteem issues, friendship problems, fitting in, moving away from friends, going to new school, and simple teen pressures. I just fucked that up, didn't I? Oh well. The victim feels dependent on the offender emotionally and appears to be the one initiating contact, longing for that connection that they believe is a real and a legitimate relationship. Offenders often encourage children by telling them that they are grown up, and the offender offers to treat them as an adult, which is enticing to a child who may be struggling at home with parents and their rules. This assists in the child feeling as though they are in control and the one making adult decisions. When the adult offender tells the child that he loves the child, normal an emotional relationship and reducing the fear of consequences, the power imbalance is significant. If a child's first experiences with affection of any kind in a relationship outside of their home has been mixed with manipulation or sexually deviant behavior, they may misinterpret warning signs, and or the abuse may be seen as normal or familiar. Children lack the capacity to make informed risk assessments of anyone in their lives, much less an adult who is pretending to care for them. So if they do have low self-esteem and the such, can you imagine what this does to them when something like this happens to them? Offenders choose victims carefully as a way in which to become the primary person in the victim's life. These victims feel as though they have been let down by others or feel misunderstood. When the offender shows them attention, it garners loyalty and dedication from the victim. The offender demonstrates a loving, caring, and agreeable relationship while manipulating and preying on the child's vulnerabilities. Offenders often frame SA with the child as a quote-unquote relationship and ensure that both are participating in a way that seems equal as to hide the true definition of this behavior, which is abuse. Offering gifts or privileges to create a sense of obligation and to normalize sexual behavior and reduce the child's ability to resist also occurs during sexual exploitation of minors. Offenders may make promises of special outings with the child and often offer gifts or rewards to victims during their conversations. Offenders plan a future with the victims to demonstrate longevity and promise that they will be together. Offenders often remind victims that they will never leave them and that they are in this together and for the long haul. Vulnerable teenagers who fear fitting in hope for lasting relationships and struggle with friendships and self-worth long for the promises of longevity, which is why this tactic works so well with teen victims. Grooming also includes the offender agreeing with the child and undermining the child's connection with people in her life who she may feel at odds with at the time. Offenders who side with the victim appeal to the victim's mindset and are adored by the victim for aligning with their feelings while working to remove protective adults in the child's life so that the victim relies only on the offender for advice and comfort. Offenders work to be indispensable to a child so that they can become the primary person in their life, making the victim reliant on the offender. Now, I never really got the sense that Aaron Spencer's daughter was being rebellious during this time or anything, but that doesn't mean she wasn't. She's not a high school, but she was a teenager in the early stages of teenage years. And I don't care what you say. We're all rebellious at that age in some way, in one way or another, whether it's not doing good in school or talking back or not doing our chores or, whatever. Everybody in the early teens is rebellious. It just is, And that doesn't change anything. She's still the victim. So it doesn't matter if she was rebellious. It doesn't matter if she dropped out of school and was a drug addict. She's still a victim. It doesn't matter if she was a drug addict turning tricks on the street. She is still a minor and she is still a victim. And the Commonwealth needs to remember that. Because I think that they will lose a lot of the jury's support if they make it sound like she invited this and she asked for it. And that they're like right on the border of that, if they push too much further, that's what they'll be implying. And I think that they'll lose the jury at that point. So bring it on, I say. Many victims continue to express love and loyalty toward their offender even after being removed from the situation. Many victims feel shame, embarrassment, and are sorry that the offender got into trouble, and they blame themselves. Most minimize the number of extent of the abuse or activities in which they engaged due to feelings of shame and embarrassment. It is quite common for a victim to reach out to an offender or attempt to do so after discovery of the abuse and even after an arrest. Victims often reapproach to apologize for their role in getting the offender into trouble and ensure that the offender is not upset with them. The victim's feelings of remorse, guilt, shame, and self-blame are the gradual normalization of the abuse. They often miss the offender and still feel they are in a loving relationship with the offender. These behaviors by victims are quite common, especially when a sexual relationship has developed and the trauma bond has been established. The defendant seeks admission of Landau's testimony based on her experience and its relevance to the precise and substantial issues in the case. Although Landau has reviewed the evidence in this case, her testimony need not address the specific evidence in this case, and unless the court or state seeks such testimony, the defense does not intend to do so. Alternatively, Landau is prepared and qualified to apply her experience to the facts of the case and testify accordingly. Footnote 2. To be clear, Landau can but need not testify about the application of her experience to the facts of the case. Landau is qualified to testify relating her experience to the facts of this case or to testify in a general manner as to the SA exploitation of children. The defense offers her testimony without reference to the specific facts of this case, but defers to the court as to the scope of her testimony in this regard. If the state and court prefer her to discuss the specific circumstances of this case, she will do so. To be clear, the defense seeks admission of her expert testimony either way, both with and without her addressing the specific facts and evidence in this case. It is the defense's position that both are relevant and admissible, and thus the defense seeks admission of her testimony either with or without it including her opinions as to the specific evidence in the case. Landau's testimony will assist the jury in understanding why Spencer's daughter appeared to go along with the quote-unquote relationship with Fossler. Expert testimony about grooming is certainly admissible if a party argues that a child abuse victim's conduct is inconsistent with abuse. Any suggestion that Spencer's daughter's conduct was inconsistent with being a victim of SA, or inconsistent with being at risk of being victimized, or inconsistent with her having been groomed for SA certainly renders this expert testimony highly relevant and admissible. It is admissible on its own, but it is certainly admissible if the state suggests, as it has in pretrial pleadings and conversations between counsel, that the evidence is inconsistent with Spencer's daughter being a victim of SA leading up to and on October 8, 2024, with her being at risk of further victimization, or with her having been groomed by Fossler before and during this time period. See, that's exactly what I just said, is they're implying, and I don't know if they mean to or not, but they're implying that she basically asked for it, that she was pushing forward with the relationship, that she initiated the reintroduction of Fossler into her life. And I say to you, that's all part of the grooming process. So it needs to be heard. A primary issue in this case is whether it was reasonable for Spencer to believe that his daughter was in imminent danger when she left her residence with the sexual predator accused of abusing her, in violation of this court's orders, while that predator was attempting to commit, and fleeing from the commission of the very same crimes that he stood charged for having committed against her. The evidence is admissible to assist the jury in understanding the evidence related to Fossler's grooming and abuse of Spencer's daughter, her actions, and the actions of other witnesses and Spencer relative to these events. It is relevant to the jury's determination of Spencer's mental state and as to the jury's assessment of the reasonableness of his belief that his child was in danger despite her apparent willingness to leave her residence with her abuser. It is certainly relevant to the unusual facts at issue in this case, and the failure to permit such testimony violates Spencer's right to present a defense consistent with due process guarantees and will deprive him of a fair trial, all in violation of the United States and Arkansas constitutional guarantee. Wherefore, the defendant, Aaron Spencer, respectfully requests this court reconsider its ruling and permit Carrie Landau to provide expert testimony at trial and for any and all just and proper relief to which he may be entitled. So, there's that. So what do you guys think? I just don't have any faith in Judge Barbara Elmore, though. I hate to say it, but I don't. Okay, so this is the excuse me. This is the order addressing defense counsel's assertion regarding opportunity to be heard on expert witness. On the record before the court is defense counsel's assertion that the court did not allow a hearing or otherwise denied the defense an opportunity to present or argue this admissibility of an expert witness intended to testify regarding the dynamics of child SA in this homicide case. After review of the record, pleadings, and proceeding, the court finds the following findings and rulings. I don't know, that was bad English grammar. Finding of fact: 1, prior to the omnibus hearing conducted on December 17th, 18th, 2025, both the state and the defense filed multiple written motions addressing the admissibility, scope, and relevant proposed expert testimony. The defense's proposed expert concerning the quote-unquote dynamics of child SA. 2, during the omnibus hearing, defense counsel affirmatively represented to the court that her proposed expert would testify to the quote-unquote dynamics of child SA and asserted that such testimony would be relevant to the defense theory in the homicide case. 3, at no point during the omnibus hearing did defense counsel A request to call the proposed expert to testify. Well, what did they think they were going to do with her? B, proffer the expert's testimony through live evidence. C, offer a detailed evidentiary proffer beyond counsel's generalized description. 4, the court did not deny defense counsel the opportunity to be heard on the issue of expert testimony. Rather, defense counsel elected not to present testimony or a formal proffer, despite having noticed that expert admissibility was squarely before the court and despite being afforded the opportunity to do so during the omnibus hearing. 5, counsel's post-hearing characterization that the court did not allow a hearing is not supported by the record and expressly rejected. Ooh, she's a bitch. 6, the court's handling of the expert issue was consistent with orderly trial management, the omnibus hearing procedure, and the court's obligation to assess relevance, reliability, and admissibility before permitting expert testimony to be present to the jury. This order is entered to clarify the record and to accurately reflect the procedural history and rulings of this court. So ordered. So does that mean that she's denying it? Yes. Oh, no, it's not. It doesn't say it's denying it. So what is, I mean, so I'm not sure what that does. To be honest with you, is she denying it? I don't know. I'm lost on that one. And this is the order denying reconsideration of opinion and reputation of said victim. God damn it. She's such a bitch. That will be I would think that would set this up for an appeal. This right here. Order denying reconsideration of opinion and reputation of the deceased. Before the court is the defense's motion for reconsideration of the court's prior order limiting admission of reputation and opinion evidence concerning the deceased. After review of the motion and the court's order, the court denies The court denies reconsideration of the court's order. The order stands as written. The court reaffirms its prior ruling. This order is entered to clarify the record and preserve the court's evidentiary rulings for trial and appellate review. So that means they can appeal on it? I'm not sure what that means. It is so ordered. Barbara Elmore. I know. So that is it for the Aaron Spencer motions. And that took a little bit longer than I thought it would because of the issues I was having at the beginning of the stream. So I think I'm going to do the Wesley Hennard papers maybe tomorrow after I get off work, or maybe Monday, because I work this is my 4-night stretch, so it's going to be a long weekend. So maybe Monday we'll go over the Wesley Hennard papers and whatnot. So I hope you guys all found that interesting. And like I said, Aaron Spencer and his family need our prayers. His daughter definitely needs our prayers. There's a Give Send Go for Aaron Spencer. I think it's givesendgo.helpaaron, but I'm not positive. I'll add it into my description. I'll look it up and I'll add it into my description. So you'll be able to, if you can, even if it's just a couple dollars, any amount helps, because we all know from watching Karen Reed and Turtle Boy that good lawyers are not cheap. If your life's on the line, you want the best lawyer, and you hate to be one of those people that can't afford a private attorney, and you have to take a public defense attorney, which I'm not putting them down. They have a huge workload. They don't get to pick and choose their cases. They get assigned cases, and they have just a tremendous amount of work to do. So they could be the best lawyer in the world. They could be another Alan Jackson for all we know. But you can't tell when you've got 50 cases. When you're carrying 50 cases at a time, you can't tell what kind of lawyer they are. They're just pushing this shit through. It's like an assembly line for law. That's why a lot of these new lawyers start out as in the public defender's office to get their feel for what they like to do and get their name out there before they try to go into private practice or join a big firm, because how else are you going to prove yourself? If you can't prove yourself carrying a 50 caseload, you're never going to prove yourself. So I'm not knocking public defenders by any means. They work their asses off. And, Kevin Reddington and I can't think of Brian Walsh's attorney, but they do public defender. They do work with the public defender's office. They're private attorneys, but they also do work as public defenders. And you've got to count your blessings if you end up with one of them as a public defender. I mean, because they are top-notch attorneys who are in that category of high-priced attorneys, and they're worth it. So if you luck out and get one of them as a public defender, you better count your blessings and never commit the crime again if you are guilty, because you'll never get that break again. It'll never happen. It'll be like hitting the lottery twice or whatever. It just doesn't happen. So anyway, also the Kimberly Singler, the young mother in Colorado, El Paso County, that killed her 2 children and attempted to kill her 3rd child, and then fled to the UK and was just extradited back to the US after 2 years of fighting to get her back here. She had a hearing yesterday, and all they did was basically hold it. So she's going to have a pretrial hearing in May, and I believe they said that's when they're going to do the bond hearing also, which why would they wait till May to do a bond hearing? I don't know. But maybe they have to do some psychological testing on her or whatever to make sure that she would be safe for the community. It would be safe for the community to have her out on bond. I don't know how that works, but so we will be keeping up with her case also. And I do believe that they do allow cameras in the courtroom in Colorado. So Colorado Springs, I believe. So yeah, we will keep you apprised on that. Also this month, the Bartholomew's have a probable cause hearing, both Bradley and his wife, Courtney. And Courtney is the biological mother of Rebecca Park, the young lady that was found in the state wilderness and with her baby removed from her. And the baby has never been found. The baby's body has never been located. And as far as I know, they have never really come forward with what they really did with the baby's body. They've alluded to some things, but I don't know if they can be trusted on that. So there's that. But they also have a probable cause hearing this month, as well as Rebecca's sister, Kim, who is being held for misleading the police officers and their investigation. And so, yeah, they have a hearing, and I do believe that they allow cameras in their courtroom, because on the website it says watch hearings here, and so it tells you to click on it. So we'll find out more about that. And I believe that's about it for what I'm going to cover this month, because there's so many to cover. We can't possibly cover them all. So anyway, I hope you guys enjoyed this video. Please remember to like and subscribe. And I think that's it. I just work hard, be loyal, and be kind. Stay warm and stay dry, guys. I will see you soon. Bye.